Good afternoon and welcome back. I'm Marcus Peter. The Supreme Court has ruled that the state of California cannot keep students' transgender identities hidden from parents. In a 6-3 ruling, the court said that parents enjoy the right not to be shut out of participation in decisions regarding their children's mental health. Andrea Picciotti-Bayer, legal analyst for EWTN News and director of the Conscience Project, joins us. Andrea, thank you very much for joining us. How are you?
I'm doing great, Marcus, and thanks for having me on.
Well, this is an important topic, and I couldn't think of anyone better to speak about this. So, Mirabelli versus Bonta. This was a long road.
This was, and it was kind of came out of, I guess it was unexpected. It came, in the late afternoon of Monday afternoon. It's a interesting procedural posture, and you know that I love that stuff as the legal nerd that I am. But it has huge impact, and already I'm hearing that the court's opinion and its reasoning are helping other plaintiff parents from these kinds of terrible policies and practices where schools are identifying that children are having problems with gender identity issues, and they're purposely keeping that information from parents. And this wasn't just one isolated school. This was the state of California had a law and a policy to affirmatively keep information from parents if a child asked, and if parents asked about it, basically to lie to them.
You and I have spoken about this in the past, and the perniciousness behind this, the sheer, I'm not exaggerating, evil behind the driving force of this movement, well, is nothing short of absurd. And the fact that human persons actually thought that they ought to push this in the name of compassion is baffling to me.
No, and to kind of develop and flesh out a little bit more how sinister the policy is, even the state of California said their reason for this policy was to ensure the safety and privacy of their students. From whom? From their parents, and so it really does show that something went really off the rails, went sideways with regard to at least the state of California's educational system, considering the primary educators of children to be a threat to their welfare and to their privacy. What was wonderful, and I love when we have these wins, Marcus, is that the Supreme Court doesn't suffer fools lightly. And not only did they reaffirm, as they've been doing with regard to the free exercise clause of the First Amendment, that these policies were, interfered with the religious parents' ability to form and shape their children, but also brought in another constitutional protection, and that's the due process guarantee of the Constitution. And it means you don't have to make, which I love making religious claims, you can make claims strictly based on parental rights, and that those claims were recognized, and in the words of the court, there was a substantial likelihood of success for the parents in making these claims against the policy in California.
You consider that the plaintiffs numbered primarily parents who were touting violations of their, frankly, constitutional rights, but also teachers who objected to the concealment policies. Their conscience were not taken into regard either.
Absolutely. Now, the court did not reach the issue of the merits of the case in general, although it really does go to the heart of what the parents are claiming. This was just a procedural issue where the court said that the injunction that was issued by a lower district court could stay in place while the lawsuit was continuing. They didn't issue any comment on the claims raised by the teachers. And that's, it's a different issue, as you're mentioning, relates to conscience rights. Can teachers that are dealing with these young kids all day long, every day when school is open, are they being bound to silence and not share information with the parents of their pupils? I think that's a very important issue, but I got to tell you that the win here for parents across the country and in the state of California is huge. I also think that it's really wonderful to see that a majority of the court really understands and embraces that the Constitution is a protection for families.
Mm-hmm. It's a protection for conscience and family. And so the 14th Amendment really came into play here.
It did. It did. Although, I was noticing one of my local newspapers, the Washington Post, didn't mention that the Due Process Clause was one of the claims that was vindicated by the Supreme Court. But basically, there's a legal notion of substantive due process, that we have these rights. And Justice Amy Coney Barrett, in her concurring opinion, really laid out that the parental rights are part of our American tradition, and cited way back to some very early cases, Pierce versus Society of Sisters and Meyer versus Nebraska. These were cases from the early 1900s dealing with the rights of parents in the education and formation of their children from the perspective of the 14th Amendment. So this is bringing back a long tradition that we've had and bringing it to light in this very important conflict that we're having. So it's not just limited to religious formation of their children, but really goes to the heart of parental rights in general.
Let alone the fact that you just referred to it as the early 1900s. I just got a pang of feeling a little old there, but
we're very old. We look great, Marcus.
Well, thank you. I'll take it. The other issue that I'm really grateful for is First Amendment rights, religious liberty, the freedom of the conscience of parents, and like you mentioned, the conscience of teachers were not argued based on the merits of the case, but at the very least, the First Amendment really was upheld here.
Absolutely. And if your listeners remember, I'm sure you do, of the great victory this past summer for parents in Montgomery County, Maryland, in the Mahmoud versus Taylor case, where Montgomery County schools were taking away the right to opt their children out of indoctrination into LGBTQ ideology in the school curriculum. The Supreme Court said that refusing religious parents, the right to opt their children out interfered with their religious rights, their free exercise rights. In this case, the Supreme Court said this is even more grievous because you're shielding and basically keeping parents from knowing very important information about their children. And so it's not just exposing them to something that's at odds with your religious belief, but basically taking parents out of the equation when it comes to raising their children in these sensitive issues related to sexuality and identity and mental health issues.
And the encouragement to flat out mislead and misinform parents about the mental health and, frankly, at this rate, the biological health of their children, that's just bizarre. It's a giant overstep in the authority of public schools and in the state.
Well, and the stakes, Marcus, are real. The two named plaintiff families, one, their daughter was being secretly transitioned, and they didn't learn about it until she tried to kill herself and was hospitalized. I mean, this is how it plays out. Young people that are being kind of kept in a fantasy without getting the supports that they really truly need. And I think it's a kind of a wake-up call to all families to really be mindful of what's happening when kids go to school or when they're in camps or whatever, and know that this is where we flex as parents, is to really step in there to accompany our kids, to make sure that they're getting the right kind of supports that they need to be able to be at peace in their lives and to be able to flourish and grow.
Yeah. And that's why the dissenting justices claiming that this was a federalism concern really doesn't apply. But I'm glad, praise the Lord for the win and praise the Lord for this landmark case. Andrea, thank you for reporting on this, and thank you for sharing this with us.
Thanks for having me on, Marcus. Have a great afternoon.
My guest has been Andrea Picciotti-Bayer, legal analyst for EWTN News. She also directs the Conscience Project. Follow her work at conscience-project.org. We've been talking about this case that has, like I said, a landmark case that has allowed for parents to be privy to their children's mental health.